Okay, before we discuss the next form, I want to talk about a form that's not up here, but you need to know about it. All right, we're going to talk about the confirmation regarding real estate agency relationship. Now, the Nevada Real Estate Division has said that it must be disclosed to each client, the buyer and the seller, which agent is working for that client. Now, sometimes we do that in our contracts, but as in a purchase agreement. However, if it's not stated in the purchase agreement that you are using or your company uses, the division has designed a form for that, and that's the form Confirmation Regarding Real Estate Agency Relationship. All that form does is state which person is working for the buyer or the seller, which agent is working for the buyer or the seller, and their company name, and they're working exclusively or not exclusively. That's all it states. It's very simple, but it's just a disclosure to let the person know who their agent is and who the other agent is for the other side. Okay? All right, on to the seller's real property disclosure. The seller's real property disclosure is a state required on almost every transaction. There are a few exceptions, and I'll cover those in a minute. It's 5 pages. This is page 1. All right, agents may not assist the sellers in completing. You cannot help your seller fill this out. This is a disclosure of everything a seller knows about a property currently and some previously questions, but everything they know currently about the property to give to the buyer during the transaction, okay? This form can be filled out after the seller gets their own home inspection. So the seller can rely on a home inspector and to fill this form out, in other words, okay? Also, this form must be conveyed at least 10 days prior to closing on a real estate residential transaction. So we try to do this pretty close up front. Because once the seller gives this to the buyer via their agents or even directly, the buyer now has 4 days to look at this disclosure and decide whether they like it or not. That's 4 working days or 4 business days. Okay, and if they agree with it, then it's fine. They sign it and they move on. But if not, then we have an issue. The other thing is, if something happens in the middle of a transaction, let's say the roof starts leaking 15 days into the transaction. This form's already been done and signed. But now the real estate agent for the seller and the seller have a requirement to disclose that to the buyer. The buyer then has 4 more days to decide whether they want to go on or not, whatever the remedy is going to be. Is the seller going to fix it? Is he going to leave it as is? Whatever the possibilities are, the buyer has to agree to it. Okay? So the issue you're going to have is hopefully nothing happens to the house during the transaction. That's after the seller's real property disclosure. But again, this is only what they know. If the roof leaks but the seller doesn't know it, he may mark, no, we don't have any problems with the roof. All right, and that's why we always recommend a home inspection and roof inspections and things like that. But this is, again, what they know. So if you see on the form, date, property address, do you currently occupy or have you ever occupied the property? All right, that's a yes or no statement. All right, the property address, whatever type of seller they are, a bank, owner, occupier, others such as landlord, okay? And then when you get down to this area here, are you aware of any problems and or defects with the following? Any problems with the electrical system? Yes, no, or NA. Now, many times it's going to be an NA. Here's a question of septic tank and leach field. If the house is in the regular city water, city sewer, you're not going to have a septic tank and leach field. So that would be NA. Now, it's not your job to fill this form out as a real estate agent, and it's not your job to help your client. However, it is your responsibility to make sure they have the most current form if you give it to them, and also your responsibility to make sure it's filled out correctly. So if they mark there is a problem with the septic tank and there is no septic tank, they need to redo that before you give it to the buyer. The buyer's agent is responsible to make sure that it's filled out correctly before the buyer signs it. All right? Once they fill all these out, they initial right here, and then the buyer will initial on that page 2. Now page 2 has a bunch more questions on these, okay? Previous moisture condition is another question that's on there. So most of these refer to, are there any problems with this system right now, or this item right now? But there are some questions on there that are previous, as in previous water damage or moisture condition. Ever been a subject of a construction defect lawsuit? Okay, these questions are on there. All right, and they have to be answered correctly. This is a very important form, and it has to be done in almost every residential real estate transaction. There are a few exceptions, and the law says to the third degree of consanguinity, which means if a mother sells their son their house, they don't have to fill out this form. But if it's your fourth cousin, you're going to have to fill out this form. Okay, so if a son sells his house to his father, doesn't have to fill out the form. All right, but again, a distant cousin, a neighbor, or whoever will have to fill out the form. Okay, now new home sales at a new home tract, they do not have to fill out this form. And if your client buys a home from a new home sales, they won't get this form. Why? Because the contractor must warranty the property for 1 year anyway. Okay. Okay, so the real property disclosure, the purpose of disclosure is for the seller's real property disclosure form is to make sure the buyer is aware of the overall condition of the property before it's transferred. That's all. This form is not required, again, for new home sales. All right. Who must provide the form? The seller must complete the seller's real property disclosure, as we call the SRPD, detailing the condition of the property, known defects, and any other aspects of the property which may affect its use or value. A real estate licensee, unless he is the seller of the property, may not complete this form, period. All right? The form must be fully and properly completed. If the seller has no knowledge, no is an appropriate answer to the "are you aware of" questions. Each question must be answered with a mark in a corresponding yes, no, or in some cases, NA again. Explanations of any yes answers are required on the property. And there is page 3 is an explanation page. There's a blank. So if you mark yes on any of these answers, in other words, are you aware of any problems with the electrical? Yes. On page 3, you must explain that yes. Now there are questions on here that have to do with CIC, Common Interest Community, otherwise known to us as Homeowners Association. If the house is in a Homeowners Association, it's going to ask you if bylaws and declarations are available. That should be a yes. But on the yes explanation page, you must explain that yes, the property is located in HOA, whatever. Okay? All right, when is it due? The disclosure must be delivered to the buyer at least 10 days prior to conveyance of the property. All right? That's very important to know. The content of the disclosure is based on what the seller is aware of at the time. Okay? The buyer may not waive, and the seller may not require a buyer to waive any of the requirements of the disclosure as a condition of sale. Sometimes banks will try to get out of this and out of filling this form out. They're not legally allowed to do that. Okay? So if a trustee, one of the people that don't have to fill out this form, if a trustee takes this house back because of foreclosure for purposes of doing a trustee sale, there is no SRPD done. But when a bank puts a house back on sale after they foreclosed on it, they must fill out this form. Ordinarily, they don't like to do that, but they're supposed to do it. Okay. If a seller requests a buyer to waive his or her legal rights under NRS 113, the buyer should contact an attorney for advice regarding the legal consequences. All right. Effective July of 2017, the following 2 additional disclosures were added to the seller's real property disclosure: solar panels, and whether the property is a part of the conservation easement, such as the Southern Nevada Water Authority's Water Smart Landscape. Those were just added. Okay, now, importantly, if on the seller's real property disclosure, they marked yes to the property being prior subject to construction defect lawsuit, then they have to disclose that on a construction defect form. The purpose of the disclosure for construction defect relating to construction defects is to make the buyer aware of any construction defects in the property. Who must disclose? If there is a construction defect, the contractor must disclose the information in understandable language that is underlined in bold-faced type with capital letters, and the property is or is not subject to construction defect claim or lawsuit. The seller must provide the following information to the buyer: copies of all notice given to the contractor, expert opinions obtained by the claimant, terms of the settlement or order of judgment, and detailed report of all repairs. This is usually a fairly good sized package. And a lot of times the attorneys who handled the construction defect lawsuit will have this on file. Sometimes it's our homeowners association. So when is it due? Construction defect must be disclosed to the buyer before purchase of the residence. If the property has been a subject of the defect claim or lawsuit, the information must be disclosed 30 days before close of escrow. Now that's important, because if you have a 30-day escrow and you didn't give this to them until 15 days into the escrow, you're going to need an extension. All right? So additional information. If the property is located within a common interest community and is subject of a defect claim or lawsuit, this information must be disclosed in the buyer's resale package, which we'll discuss in part 2 of disclosures. Okay? Lead-based paint. This is a federal disclosure on any house built prior to 1978. So this disclosure states, and your seller will have to initial and check these, that it's a possibility the house was built with lead-based paint or had lead-based paint in it, because that's the way paint was made back then. Okay? So we do have older homes here in Las Vegas, for example, that we have to do this disclosure. And your seller is going to check the presence of lead-based paint and or lead-based paint hazards. And they're going to say, are known lead-based paint and or lead-based paint hazards are presently in the housing? Or seller has no knowledge of lead-based paint and or lead-based paint hazards in the housing. And seller has provided the purchaser with all applicable records and reports pertaining to lead-based paint, or the seller has no reports and records pertaining to. They have to check those that apply. The purchaser, the buyer, will have to initial, purchaser has received copies of all information listed above, or the purchaser has received the pamphlet, Protect Your Family from Lead-Based Paint, or from lead-based paint in your home. All right? So the next one is the purchaser has also received a 10-day opportunity to mutually inspect the property, or has waived the opportunity to conduct a risk assessment inspection. The agent here has to initial is the seller's agent. Agent has informed the seller of the seller's obligations under 42 United States Code of their responsibility to ensure compliance. And the seller, the buyer, and their agents, respectively, have to sign and date this form. And then you must have this, again, on file in your office. All right? It's pretty self-explanatory, but you also have to make sure that your client gives and gets the lead-based paint pamphlet also. Okay? Lead-based paint, again, purpose of the disclosure is to make the buyer aware that the residential property built prior to 1978 may present exposure to lead. Federal law requires that the seller disclose any known presence of lead-based paint hazards, and the disclosure is on federally prescribed form. That is the only form that you'll see, and must be made as a condition of sale prior to conveyance of the property. Additional information on the disclosure form: the buyer must acknowledge receipt of the APA disclosures booklet, that's the one about lead-based paint and Protect Your Family, and copies of the reports if there are any available. Additionally, the buyer will receive a 10-day opportunity to conduct a risk assessment, but they may choose to waive that also.